morning. This is Rich Sierra. I'm the president of Florida Small Business Legal Center. I'm your host of the Business SOS podcast. It's based on my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble, and you can ask for it at your local bookstores. Today, this is episode number 26 of Business SOS. Very excited as we continue providing you some really, I believe, valuable content that as a business owner you will use, you can use in your business. In episode 21, a few weeks ago, I talked about the 7 common legal mistakes business owners make in litigation. So there are more mistakes that I want to share with you, and there'll be like 5 mistakes that are made by small businesses. And some of them have happened in the last few months that I wanted to share with you. And they're not a repeat from the last one we talked about. And simply because I want to make you aware of those because these are common. And remember, as a business lawyer, as a business attorney, people come to me because something happened along the way. Something went wrong in a business transaction. And basically most cases, a dispute between business owners happened because an agreement was allegedly breached. Something went wrong in whatever agreement they made, whether it's with a vendor, with a partner. There was something wrong that went along the way, and that's why they come to me. So I can go through a lot of mistakes, but I'm trying to give you the most common ones simply because I want you to recognize them. I want you to recognize that what I call the yellow lights, like, you know what, something here is, I need to take a look at this further, or I need to find out more, perhaps call an attorney. So I wanted to at least share those with you so you don't have to run into these landmines as well. And it's less expensive if we learn lessons through others than going through those ourselves, and actually less painful. So let's get right into it. One of the things that people come to me often and ask me, I want you to review a lease agreement for me. I want you to review an NDA. I want you to read a financial disclosure document. And we had, in a couple of episodes back, we talked about FDDs as well. And I'm happy to do it. I'm happy to review those documents, interpret them for you, and basically answer any questions. But when people come to me and there's a breach of contract or some type of issue, a mistake that I see very common is like, and it seems so simple, I said, do you have a copy of the contract, of the signed contract? And they said, no, I don't have it. Where is it? Oh, it wasn't DocuSign, and then, because now we're doing things through electronic communication, and the link expired. Do you have a way of getting a copy of the contract? No, I don't have it. And then the people that signed the contract on the other side, they're nowhere to be found. So I guess, it seems intuitive that you want to have a copy of the signed contract. People sometimes forget. So, something that is a mistake to avoid, if you sign a contract, absolutely be certain that you have a copy of the signed contract. If you get the link from DocuSign, download it, put that PDF in a folder. Okay, if you want to print it out, that's fine. The point is, in order for you to enforce a written contract, it's helpful to us if we have the complete signed document, including any addendums or changes that have been along the way. So, a mistake to avoid, just get a signed copy of the signed contract. Again, seems common sense. Unfortunately, it's happened more than one occasion in the last few months that I needed to kind of bring it up because I talked to people about, you have a copy of the contract. No, I don't have it. I have a draft. A draft it's very difficult to enforce a draft. So just give me the contract. Number 2, I also get comments after the fact, when, especially for example, lease agreements. There's a dispute with the landlord. The landlord this happened a few months ago. The tenant was about to leave. They now want to renew the lease, and or had an option to renew the lease. but the landlord asked them to replace the air conditioning as a condition to renew the lease because the air conditioning was having problems. It was not working. So the client came to me and asked me, hey, am I responsible for this? And I said, well, what does the lease say? I said, I don't know. I didn't read it. Okay, so I guess number two, you got to read every document that you sign. When we read documents as attorneys, we read it for a number of things, see like what the terms are, but also the legal significance, whether it's a legally binding document. I can tell you right now that if you have a lease agreement, it was drafted by an attorney for the most part, with some exceptions, depending on the terms, it will be a legally binding document. Even if the terms are not good terms, okay, it'll be a legally binding document. So that in and of itself is not a reason to, not to read the document. So my lawyer read it, he said it was fine, but you don't know what fine meant. Fine meant like, yeah, it looks good. You have all the components, you sign it, you're bound by it, their obligations are set, the terms are clear. But if the deal is not good for you, it doesn't mean the document can still be fine, but it doesn't mean that it's a good deal for you. So you have to understand what you're signing. And you have to read your own documents. We can do so much for you, but reading it for you in and of itself, if you don't know what questions you have, we have no idea what you're looking for. We'll read it for you and point out some things, but you're responsible as a business owner to read your own documents that you sign. So read your documents, highlight sections that you do not understand, write questions down, and then contact your attorney and say, I read this document, I have the following questions. Now we can have a more productive conversation because not only I'll be able to answer your questions, but I'm going to be able to point out some things that perhaps you were not aware of. But it is your responsibility to read the document. Very, very important. And also, another point that I want to make regarding contracts, which will be mistake number 3, sometimes contracts are signed, and this is an example of a lease agreements that are signed, and then because of something happened along the way, whether a business slowdown or whether there's a relationship with the landlord, in this case, there's modifications to the contract that the landlord says, you know what, something happened, I'm doing, I'm repairing the parking lot, and you had a slowdown in sales, so I'm going to charge you half rent this month. Just give me the half rent. There's nothing in writing. In fact, I'm going to do it for 3 months. I'm going to basically, next 3 months, just give me half. We're good. And it's basically a one-on-one, and you're like, okay, fine, I'll give you half rent, and not a problem. Okay? And that continues for a while, but there was nothing in writing. In a lease agreement, modifications must be done in writing. That's critical. So if you're going to have an agreement that is a written agreement, and in fact, in many contracts, you have clauses that say that this agreement shall only be modified if it's in writing signed by both parties. So you want to make sure that it's in writing and it's signed by both parties. It could be an email confirmation. It could be, preferably, if it's a document that has a written document, ink document, or electronic document, you want to basically memorialize that it said, just to confirm, this agreement shall be modified as follow. 1, 2, 3, 4, sign here, date. Again, that could be done very simple, but it's also for your protection. The reason I do that is for a number of reasons. Is that, say that landlord sells the building, which happens often, the new owner will take all these contracts and begin to look at the rent rolls and say, okay, this is the rent that should have been paid. This is the rent that I receive. And there's a discrepancy. And You say, what happened here? No, I told him to pay half. I said, well, that's not, do you have any writing about this? No. Guess what? The new owner sends you a bill for whatever you didn't pay before. And if you don't have it in writing, it's going to be difficult. There are defenses to that issue in terms of estoppel, but for your protection, any type of written agreement that you have that is modified, and I cannot impress this enough, you have to request a written amendment to the agreement. Do not settle for a verbal confirmation. Do not settle for an email. Although email can be construed as an amendment, and there are other issues with that. But the point is, whatever, if you have a written document that requires modification, get it in writing, and continue insisting for that until it is done. Again, it's for your protection. Here we'll talk about a little bit about litigation. Oftentimes, and now because we have information available on the web, and now with AI, people are doing that a little bit more. And there are friends that want to help. Sometimes when you're in the middle of litigation, you tell your friends, or somebody tells a family member, or they know a lawyer that may not practice in that area, or somebody from out of state. So I guess a mistake number 3 in this case is that discussing your lawsuit with people outside of the lawsuit, other than your spouse and your attorney, or a professional that has been hired specifically to assist with the litigation, like an accountant or an expert, the lawsuit should not be discussed with anyone for a number of reasons. If you're in the middle of a lawsuit, whether you're suing somebody, you're the one being sued, the moment you talk to someone about anything regarding the lawsuit that is not within the realm of protection, like an attorney or your spouse, that person becomes a material witness to the lawsuit, because whatever you said is what is called an admission by a party opponent. Meaning that all your statements, anything you said to that person, that friend who's trying to assist you or listen to you, now can be called to testify against you for everything that you said. So not only have certain issues in the past that people not only sharing information about what I discussed with them to other parties, which in essence almost sometimes it could happen way of attorney-client communication, but also then another person becomes a material witness as well, and which basically adds another layer to the litigation that doesn't have to happen. And again, it's for your protection. It's simply for you. You have attorney-client communication with the attorney when you're talking to the attorney. And that's a very, very important protection that you have. And you might end up waiving that protection by talking to friends and family about your litigation. So it's just not helpful to you. And it's also not helpful when you have a situation in where you have that friend or relative giving opinions about the case, and then you acting upon those opinions and going back to your lawyer and say, this is what I want to do based on my friend's opinion. Because then the attorney has to basically re-explain what happened in the course of action that has been decided and why the friend's opinion might not be the best course of action for you. So people are well-intended, but at the same time, you're hiring an expert to help you with your legal matter. And you have to choose. Do you want to have your friends continue the case? Or you're going to have your lawyer continue the case, who's the expert that you hire to resolve it for you? So my opinion here is that if you hire somebody to help you, have an attorney to help you with your legal matter, that attorney is the one who you have to discuss anything with, And if you want to bring anything issues regarding anybody's told you what you read on the web, that's fine. But you got to keep the communication within that circle, within that cone, because it's only for your protection. It's only to assist you to have a better outcome. And you have to trust that professional. And you have a difference of opinions, that is fine, and that can be addressed. But we have third parties interfering with your attorney-client relationship, and then it becomes a difficult situation for the attorney to try to help you, because then not only has to try to help you as the client, then he has to deal with an outsider who he or she does not know, interfering with that relationship. And nothing is going to come good out of it. Again, people well-intended, but my recommendation is that you have your attorney, only communicate with the attorney. Do not go outside. And if you're not happy with the attorney, you can always change the attorney. There's nothing wrong with that. Okay? But also the attorney has an option as well. If there's an issue that you're always butting heads with the attorney because of an outsider is interfering or giving you opinions that are not based on facts or not based on law, and it's an unqualified opinion because they're looking at simply from a friend's perspective, the attorney also has a choice not to continue the case. So it's a two-way street here. Your relationship with your counsel, it is extremely important. And you don't want to create a wedge between that relationship by having third parties related to the matter interfering. So I just want to share that with you. Talk to a lawyer if you want, but keep it within you and your attorney and, of course, your spouse, and leave it at that. Anything outside, the spouse cannot be asked to testify because of what is called spousal privilege. So that's a different conversation, but the answer is she cannot be brought in to testify about what you tell him or her about the case. So I wanted to at least share that with you. And following that same line in terms of sharing it with third parties, sharing anything regarding the lawsuit with third parties. Sometimes we as attorneys negotiate, especially business lawyers. We're spending most of our time negotiating, and we're very good at this. The good thing about business litigation or business problems is that we have a white canvas to work with. We can be very creative in how to come up with solutions. It's not, there are different ways of solving a business problem. Sometimes it's money, sometimes it's an accommodation, sometimes there are different ways of doing it. So creativity comes into play here, but also communication with the opposing party, the opposing counsel on the various terms. And then sometimes it takes a number of conversations. It's not a very, linear type of communication. Sometimes it requires we agree on a certain portion of it, and then we begin to work in those areas that there seem to be disagreement and try to figure out a way to get past those, and then we continue working on those. In my experience, crafting a negotiated settlement sometimes is harder than litigating. And I'll tell you why. Because litigation is more, you have discovery, you have depositions, you have your trial. It seems to have a schedule. And you got to be creative in terms of presenting your evidence, but you have a kind of a set format. And it's combative. It's I'm going to prove my case against you, vice versa. I'm going to find the mistakes you make. I'm going to take advantage of those mistakes. It is basically some strategy, some tactics, and gamesmanship, the way it works. When you're dealing with a negotiated settlement, we're trying to negotiate a solution, you need to use a lot of creativity, a lot of diplomacy, a lot of finesse, and also credibility. So sometimes when it is important to know that as attorneys, our credibility is key, especially with our clients and also with opposing counsel. Opposing counsel is a professional. We're adversaries regarding the case. We're not enemies. In my experience, cases settle faster and more efficiently when the opposing attorneys have a cordial and professional relationship. We're members of the bar, we're professionals, and we will do our job ethically and professionally. But at the same time, it is important that, in my case, when I tell opposing counsel, we will agree to A, B, C, and D. This is what we're going to do. And opposing counsel relies upon that representation after everything has been said. And then we go the next morning and tell them, we're not going to do that. We change our minds. From that point forward, the credibility of you, the client, and the attorney has been damaged. Simply because at that point, the opposing counsel will say, I'm not sure if I can believe in you again. Now, there are reasons to change your mind, but you explained the reason the mind was changed is because we got new information and because this happened, or et cetera, et cetera. That is fine. But it's important to know when to maintain that credibility is essential to have a proper negotiated settlement. So negotiation is part of art, part of science. It's not a clear-cut, discipline. And there are many books on negotiation, and maybe I'll bring a negotiation expert here at some point. But my point is this, is that don't put your attorney in a situation that he or she has to change their mind for no reason whatsoever. Simply because then it's going to be difficult for the other side to believe you. And it goes both ways. If an attorney tells me they're going to do something, or I can rely upon their representation for something, and I rely upon that, and all of a sudden they do something completely different than was said to me on that representation, I already know that it's going to be difficult for me to trust that attorney or trust that party going forward, simply because they did not follow through in what we discussed beforehand. So my recommendation is the communication with the attorney is essential, but also understanding that the credibility in the negotiations is extremely important, because that's going to determine if your case is going to settle, but also there's a greater chance of succeeding on a settlement if there's credibility and weight on your representation. So I want to share that with you as well. The last point I want to make is that on settlement agreements, sometimes people, unfortunately, and the point is this, do not enter into a settlement agreement that you're not most likely certain that you're going to fulfill. And this is important, because when you settle a case, you settle a dispute, everything that happened in the past gets merged into that document. So whatever dispute you had before, it goes away. No matter what the breach was, no matter what damages, everything goes away. So everything goes merged into that particular document. So whether it's you're going to be paying money, whether, in this case, say, for example, you have a payment plan for any type of monetary settlement, whether it's obligations you got to meet, whether it's a non-disclosure, whether it's non-disparagement, whatever the terms are, you have to make sure that, going back to my first mistake, you got to read the document thoroughly. Number two, you have to understand it. If you do not understand it, ask your attorney, hey, explain this to me, and do not sign it if you do not understand it. So that way you can get better clarity as to the terms of the settlement. Number four, if you're obligated to do something, say, for example, you got to pay a certain amount of money per month for a number of years or for a time period, you have to make sure that you actually can fulfill that settlement. if you're not comfortable, you're not really sure you're not going to fulfill the settlement, tell your lawyer, listen, I'm not sure if I can really fulfill this. I'm not really sure if I can actually do this. Because what happens is this, is say you have a payment schedule on a settlement agreement, and then you do not fulfill it, then very likely, you will have some type of final judgment, you will have some type of penalty, and it's very little the attorney can do to protect you at that point. Once the settlement agreement is signed, everything merges into the document, everything is included there, and if you do not fulfill the obligation of the settlement, provided, of course, the other side has not breached that settlement agreement, then there's really very little an attorney might be able to do to help you and protect you at that point, because the settlement is what it means. It's you solve the problem. This is what I'm obligated to do. We agree to these terms. So, in that particular case, if you are not able to fulfill it, then you have to do whatever consequences are included within the document in the case of a breach. So in terms of, settling in a case, if you're not really sure, you're not comfortable with it, talk to your lawyer. Okay? Don't be pressured into signing a settlement you're not comfortable with. You're never going to be 100% comfortable. You're going to be unhappy with it, for the most part. That's what settlements are for. Both people end up a little bit unhappy. But the point is this, is that if you're apprehensive, discuss it to see what can be done to reduce your apprehension, so that way, you can fulfill whatever obligations they are within the settlement agreement. Just to recap some of the mistakes that I'm suggesting here that are common, but also they're avoidable. Number one, when you sign a document, make sure you get a signed copy of the document and save it in a safe place, whether it's a Dropbox, printed copy, whatever it is, but get a copy of the signed document. Number two, read the document. You got to read the document as well and ask questions to your attorney about what the document contains. If you don't have any questions, ask for them. Remember, at prior episodes, I'd said that if you do not understand a document, do not sign it. That's very clear, and that's one of my rules. If you have a written agreement that needs to be modified, make sure it's modified in writing as well. Do not modify the agreement orally or by a text or messenger. We need to maintain certain formalities, and it's very simple to just have a written agreement signed. Listen, we're going to modify it this way. Do me a favor, sign here. We can continue, okay? And I know sometimes people want to do things fast and very informal, but it just makes our life more difficult if we're not able to have a written document because we're trying to put it together. And there are ways that you can enforce a oral modification to an agreement, but we don't want to go into that right now. Just the rule is, just get it in writing. Saves a lot of headaches. You have a legal problem, a legal issue, discuss it only with your lawyer, your spouse, or your partner. Also, make sure that whatever course of action you decide to take, that you're sure about it, so that way you don't have to change the course of action midstream in terms of the communication that you give to the opposing side. You want to maintain credibility in your negotiations in order to be effective. The last but not least, obviously, is when you enter settlement agreements, they should be in writing, of course, but also make sure that whatever terms you have agreed upon, you can fulfill to avoid any potential issues of violation of a breach of a settlement agreement, which makes it difficult to defend later on with some exceptions. But whatever terms that you have agreed upon, make sure you can fulfill them, so that way you can complete that legal process and you can move on, and that chapter of the legal issue has been closed. So I want to leave you with that today. I think this is an important topic because it goes and ties into the book, Common Legal Mistakes. And my goal here is to share with you some thoughts that as a business owner, you're facing challenges every day. I mean, there's not a day you don't have a challenge. So if through this podcast you recognize or identify something that may come up, then, I've done what I wanted to do. We should share those thoughts with you as well. If you have any questions, if you'd like me to discuss any legal question that you may have, a legal issue in your business, please send me an email at richsierra.com. And if I select your question or discuss your issue here in the podcast, I'll send you your free copy of my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. If you want to learn more about our legal services, our website is floridasmallbusinesslegalcenter.com. We're in Facebook at FSB Legal. If you'd like to watch the video of this podcast, we're on youtube.com/@RichardSierra. We're on X at Rich_Sierra. Instagram at FSB Legal. Make sure you follow us. You can call us at 866-842-5202. Remember that Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble, and you can ask for it at your local bookstores as well. Remember to follow this podcast. Give us a review if you like the podcast. Hope you did. And I appreciate you listening to me. We're on Apple Podcasts, Spotify, wherever you enjoy your shows. Remember that this is Rich Sierra, president of the Florida Small Business Legal Center. Remember that my goal is to help you succeed.